10 SC 92020. So I will just put it, do you wish to go ahead and deal with that particular case? Ms. Mormon, would you like to waive arraignment on both those two cases, the 10 SC case as well as the indictment then under the new case, which is
22 SC 2573.
22 SC 183572. That's the new case, correct?
In order to 182573.
It's 183572. That's the re-indictment.
Yeah, the calendar has y'all are gonna have to probably correct. See, the clerk is written on the 22 SC 183572.
That's the re-indicted case.
Yeah, that's the re-indicted case. Okay, all right.
Okay, so the 10th case is the motion for new trial that Newkirk granted. So the question for me is, do you want me to keep this case along with that case to deal with it, or put that to the side? What would you like with the 10 case?
Set the trial after this case.
Yeah, we'll just put it in a trial posture and put it on a trial calendar. In fact, it can go on that 9.
Because we need to keep account for the 10.
I'll put it on the 9 January 2023 calendar, and I'll probably, unless we got, and more than likely I will move it as I get my other trial dates come later this fall, okay? But just for accountability purposes, I'll continue. I'll go ahead and just lump that case with it. But as for the new indictment 572, would you like to otherwise waive formal arraignment, enter, have the court enter a not guilty plea on behalf of your client, otherwise have at least 30 days from the receipt of discovery to file any motions now? Okay, all right. I'm going to go ahead and put it on that 9/23, January 9th, 2023 calendar, okay, and and I'll also track the 10 SC 2020 case, but, or the 10 SC 92020 case. We'll put that on another calendar, okay? All right, thank you. All right. Mr. Greer, you can be excused at this point in time. Your attorney, Ms. Mormon, will talk with you a little bit later on, okay?
You're still in this waiver.
Okay, oh, we have a waiver issue with him? Okay. All right. Do you want to go ahead and take that up now?
Yes, please.
Okay, all right. Well,
I can argue.
all right.
Make an additional inquiry, please.
You can.
You had mentioned earlier, and asked me if I was prepared in order. That's the presume this denying the state's motion to remove Mr. Steele as attorney for Mr. Williams. Both there are 4 individuals who are mentioned in the reason for conflict, and we addressed one of them, about to address the second one, and the other one will not be addressed until at least the 8th. I would record representing before law. I'm drafting that order until we address all of those.
No. Go ahead and do the order for the ones that we have for today. I'll enter a supplemental order when those 2 folks are taken up, okay?
Yes, sir. May I say something else also, Judge?
You can.
Earlier, the court made reference to, I saw asking some questions, some time questions in regards to our manner of proceeding. And I think some exception to the court's belief, assertion at that point.
This is, okay, since you brought it up, no, you may not at this point in time, because you interrupted me to begin with, okay? We're here, Mr. Adams, here's the thing about it. You have to be patient with the court. You have to be patient with the court, because I got a lot of freight I'm trying to manage. I'm always going to let you have and consider everything that you tell me and any motions that you file. But what you do is when you jump me, meaning that my procedure, or you jump in front of other people, then that it doesn't sit well. So I'm just going to tell you, if I offended you in any way, please take my apologies for it. It wasn't my intent to do so. I consider you to be a very fine attorney, and I've known you professionally for over 20 years. But, having said that, I do get to control the method and manner of how things go in the courtroom.
I understand that, Judge. I know this is your court, but I was asking a question to get some clarification, and I just feel like the court telling me to sit down or what I can do is take my seat was not appropriate. I treat the court always with deference, with respect, and the only thing that I ask is that the court treat me the same way. I'm required to do that, Mr. Adams. We both are under the rules of professional responsibility. Yes, sir. Okay? Anything else, sir? That's all.
Okay, all right.
He's starting with the judge. Crazy.
Okay, who do we have at this point in time? Okay. Let me see if I can get Mr. Greer for you.
Not smart.
Okay. Let me mark that as the next court exhibit in order. I want to say it's court 3. Is that correct, Ms. Williams? Okay, all right. Okay, Mr. Greer, can I get, I should say, Ms. Amana, can you go ahead and unmute, Mr. Greer, please? And the reason I muted him again for Cal folks is because there's a lot of background noise in the jail. So, yes.
Yo, you see all them screens? They all in jail live streaming.
Okay, all right, I think he's unmuted now. Mr. Greer, again, good afternoon, sir. Sir, I'm holding at this point, let me go ahead and swear you in at this point in time. Can I get you to raise your right hand for me, please? Do you solemnly swear or affirm that the evidence you'll give in the matter now hearing shall be the truth, the whole truth, and nothing but the truth, so be done, so affirm? Yes, Your Honor. I'll put your hand down. Okay, all right. So I'm in possession of a waiver for you. It's addressed from the law office of Lawrence J. Zimmerman, PC. And I believe it was dated or authored on the 20th of May of 2022. All right, did you have an opportunity to to read that particular document? Yes, Your Honor. Or before Mr. Zimmerman penned it, for you to discuss the things that we'll cover in regards to conflict? Yes, Your Honor. Okay, I'm going to read it because it's very short. It just says, Dear Brian, I've met with my client, Quantavious Greer, regarding any potential conflicts of interest. He met with you, is that correct? Yes, Your Honor. All right, he being Mr. Zimmerman, right? Yes, Your Honor. All right, and he advised you of all the issues regarding your prior representation of him and your current representation of Mr. Jeffrey Williams. Is that correct? Yes, Your Honor. And then you discussed with Mr. Zimmerman all the issues regarding potential conflicts in this matter. Is that correct? Yes, Your Honor. Is that right? Yes, Your Honor. Okay, and you are, he is insistent that you represent Mr. Williams, and he waives any conflicts of interest. Is that correct? Yes, Your Honor. And it further says, I advise him that the court may ask him questions about these issues on the record. Is that correct? Yes, Your Honor. Did he tell you that? Yes, Your Honor. Let me just kind of ask you a couple other additional questions, okay? Because this is, I just want to make sure that you understand what you're waiving at this point in time. Do you understand that the state could offer to dismiss the case against one co-defendant, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, Your Honor.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other? So it could be helpful to somebody else and be harmful against you. Do you understand that?
Yes, Your Honor.
Also, do you understand that the lawyer may want to use a defense theory, witness evidence, or argument that's helpful to the lawyer's current client, and that would be Mr. Williams, and harmful to you? You understand that?
Yes, Your Honor.
During closing argument, the lawyer may want to argue the evidence against his current client is less than the evidence against the former client. You understand that?
I understand, Your Honor.
All right. Do you also understand that if there's sentencing, the lawyer may want to argue that his current client is less culpable than his former client?
Yes, Your Honor.
Do you also understand that the lawyer may have learned something from the former client that helps the current client but hurts the former client?
I understand, Your Honor.
All right. Did you give this waiver freely and voluntarily? It means your own decision to enter a waiver this afternoon as to counsel, waiver of potential conflict of interest as to counsel.
Yes, Your Honor.
And you do so freely and voluntarily. It's your own decision. Nobody's forced or threatened or tricked you into doing so.
Yes, Your Honor.
Have you had an opportunity to speak, to fully consider this waiver
Yes, Your Honor.
and any potential conflicts of interest?
Yes, Your Honor.
All right. Any further inquiry on Mr. Adams?
No, sir.
All right. What about you, Mr. Good, or Ms. Rosenwasser?
I believe that satisfies the experiment.
Okay, and remitted that is number 3, is the letter from Mr. Zimmerman as Court Exhibit 3. Okay, anything else? Mr. Adams? No, sir. Okay, all right. Can we go ahead and arraign Mr. Williams on the new charge, or the new indictment?
Yes, sir.
Okay, all right. Do you want to go ahead and waive formal arraignment, otherwise have the court enter a not guilty plea, and otherwise have at least 30 days to filing motions on under the new indictment, that being 22 SC 183572, sir?
Your Honor, we waived formal arraignment. We do enter a plea of not guilty on the new indictment. We do ask for the court to grant this previously. Previously, the court had given us 60 days from receipt of all discovery to file particularizing motions. We ask for that at this time.
I'll give you 30 days, and the only reason why is because you all have started the discovery process. I don't know whether or not. I suspect you've probably gotten some discovery, but I'm flexible with that. But let's go with 30 for the time being, okay? Okay.
And Judge,
Yes, sir.
Of course, our waiver of arraignment and plea of not guilty is subject to the statements made previously by Mr. Steele in regards to
I will incorporate those and include those, and I believe that Mr. Greer owes an order in that respect, and we can incorporate that by reference, okay?
I don't like this.
Thank you.
Okay, are there any other waivers that I need, Mr. Adams, I need to take up in regards to Mr. Steele that are here today? I don't know if there are any, because
Yes, Your Honor.
yeah, Ed Adams is on, and as well as Ms. Merchant, and I think that they have, Martinez Arnold. Let me see if he's on. Is Mr. Arnold, are you on? Martinez Arnold? Are you Mr. Arnold?
Yes, sir.
Okay, I guess he is there. All right, okay, all right. Let me see if I have his waiver. Ms. Merchant and Mr. Adams, thank you for being your patience with us today. I'm going to mark this one as court exhibit next in order, and that would be, I think, court's 4. Mr. Arnold, where are you, sir? Can I get you to raise your right hand for me, sir, if you wouldn't mind? Do you solemnly swear or affirm that the evidence you'll give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, so affirm? I didn't put you in there. Okay, all right. Mr. Arnold, just want to go through a couple things with you to begin with. Are you aware that Mr. Adams, on your behalf, penned, that is, authored a letter to Mr. Steele on the 19th of May, 2020?
Yes.
Are you familiar with the contents of that letter, sir?
Yes, ma'am.
In terms of the waiver?
Yes.
Okay, I'm just going to go through with you again, because it's 4 paragraphs, and I'll just read it and ask you some questions as we go along, okay?
All right.
Is that all right?
Yes, ma'am.
Okay, all right. It says, Dear Brian, I am authorized to make statements herein on behalf of my client, Martinez Arnold. I represented Mr. Arnold in the state of Georgia versus Martinez Arnold, indictment 14 SC 131032, Fulton County Superior Court, and which is a case involving a shooting at Lenox Mall. Is that the indictment that is referenced that he spoke with you about?
Yes, ma'am.
Okay, all right. Mr. Arnold pled guilty to reckless conduct on or about February 18, 2015. That's correct?
Yes, ma'am.
All right. I am aware of the state's motion to disqualify you, and that would be Mr. Steele, as counsel for Mr. Jeffrey Williams in the state of Georgia versus Mr. Jeffrey Williams et al., and that was under indictment 22 SC 182273. And that was the indictment at that point in time. Do you understand that?
Yes, ma'am.
Do you understand the case has been re-indicted under 22 SC 183572? You understand that, right?
Yes, ma'am.
Okay, all right. And that is the matter in which Mr. Arnold, that would be you, as a co-defendant. You understand that?
Yes, ma'am.
Okay, you have to speak up so I can hear you, okay?
Yes, ma'am.
Okay, all right, thank you. The motion to disqualify is based in part on the allegation that you represented Mr. Arnold on matters relating to the 14 SC 131032 case. That's your understanding, correct?
Yes,
And
ma'am.
Mr. Steele representing in that case, and he's representing Mr. Williams in this matter. You understand that?
Yes, ma'am.
Okay, all right. I spoke with Mr. Martinez Arnold, this is Mr. Adams, okay, regarding the state's motion to disqualify you as counsel. I explained to him what the state alleged with regard to you, specifically you, that Brian Steele represented Mr. Arnold on matters relating to the indictment we just mentioned, 14 SC 131032. I further explained to Mr. Arnold as you the relevant law and ethical concerns at issue, and specifically that you're entitled to conflict-free counsel, and that you were representing Mr. Williams in this indictment, 22 SC 182273, which is now indictment 22 SC 183572, in which you are co-defendant. You understand that, right?
Yes, ma'am.
Okay. And he explained to you that you can object to Mr. Steele representing Mr. Williams.
Yes, ma'am.
Okay, all right. And after providing the explanations that we just kind of went through, did you make it clear and unequivocal to Mr. Arnold that Mr. Adams had said that you had never represented him relating to any shooting at Lenox Mall or any other matter?
Yes, ma'am.
Okay, basically what Mr. Adams is saying is that Mr. Steele didn't represent you in any shooting at Lenox Mall. Is that what you understood?
That's correct.
Okay, all right. Or any other matter, correct?
That's correct.
Okay.
So you see.
All right, and then, you explained that he believes that his friends contacted Mr. Steele shortly after the shooting to inquire whether there's an outstanding warrant for you. Is that correct? Say again?
That's correct, Your Honor.
Okay. And you insist that you never spoke with Mr. Steele about the case or any of the facts and the surrounding circumstances, correct?
That's correct. Correct, Your Honor.
All right. Let me ask you a couple of additional questions, just to make sure. Do you understand that the state could offer to dismiss the case against one of the co-defendants, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, Your Honor.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other?
Yes, Your Honor.
That the lawyer may wish to use a defense theory, witness, evidence, or argument that is helpful to a lawyer's current client but harmful to a lawyer's former client?
Yes, Your Honor.
During closing argument, the lawyer may want to argue that the evidence against his current client is less than the evidence against the former client.
Yes, Your Honor.
If there is a sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, Your Honor.
And a lawyer may have learned something from the former client that helps the current client but hurts the former client.
Yes, Your Honor.
Do you intelligently, knowingly, and voluntarily waive any potential conflict of interest that would stem from any involvement you had with Mr. Steele and or indictment 14 SC 131032?
Yes, Your Honor.
All right. And you don't have any issue with Mr. Steele representing Mr. Williams?
Not at all, Your Honor.
Did anyone force, threaten, or trick you into entering this waiver? You offer this waiver freely and voluntarily, is that correct?
Correct.
Mr. Owens, anything, sir? Mr. Healy or Ms. Rosenwald or anything?
We believe that satisfies any conflict with Mr. Arnold.
And as I mentioned earlier, if any conflict should develop, please, notify all concerned at the earliest time possible, and the court will also, if I believe that there is a conflict, I will raise that issue and ask you all to address it. Well, I have Mr. Arnold here. Let's see. Mr. Adams or Ms. Merchant, Madam and Sir, would you like to otherwise waive arraignment on the new indictment? Do you wish to be arraigned on that today? Or can we go and do that?
We can waive arraignment on that, Judge, and we filed a couple motions on the old indictment, and then I filed a motion adopting all of those on the new indictment. And I think that would take maybe about 2 hours to be heard. We'd like to have our renewed bond motion heard with those motions. One is a motion to dismiss based on double jeopardy, one is a motion to dismiss based on a statute of limitations violation, and then one is a motion to sever. I think the sever could probably wait, but the other two dispositive motions would probably make sense to be heard at the same time as bond.
Okay. When did you file those, Ms. Merchant?
I filed them in late June, early July.
Okay, if you'd be so kind, you may have already, if you could send Mr. Kearns, my staff attorney, a copy of those as well, and I will take a look at those, and we will determine if I can hear all of them on the 8th. I'll endeavor to do so, but as I mentioned, there's a lot going on, so I'll, at least with the bond, we can wait on the severance, and I'll see if I can hear the other two at that point in time, because I would concur that they probably need to be heard up front, but more to follow on that, okay?
Great, thank you so much, Judge.
All right, I will go ahead and authorize you to waive formal arraignment, enter a not guilty plea on behalf of Mr. Arnold, and otherwise give you at least 30 days from the receipt of the new discovery or additional discovery to file any additional motions in this case. And we'll hear the motion for, I'll authorize the your motions that were filed and under the prior indictment ending in 273 to carry over, and otherwise the state's going to file a motion in order for those, and I will adopt those, and I'll authorize your.
It's a terrible thing that they could deny bond. That shouldn't be a thing. You got the money to get your bond, give them the bond. That's a real fucked up thing. That's a glitch in the system for sure.
It was the 7th of July, I just checked.
Okay. And that would be, and then I will, that will be the 8th of September.
Okay, great.
For those motions, okay?
Wonderful, thank you so much, Judge.
All right, Mr. Adams, anything else, sir?
No, thank you.
All right, thank you all for your patience, really appreciate it today. Ms. Rosenwasser or Mr. Geary, anything else as it relates to Mr. Arnold? All right. And then I will release both you councils as well as Mr. Arnold, and we'll see you all on the 8th of September, okay?
Great, look forward to it. Thank you, Judge.
Thank you, madam. Take care.
Take care.
Yes, ma'am. Unless you have anything else, Mr. Greer, I think I've excused him already. And I'll also excuse Mr. Arnold. Yes, sir. You may be excused. Thank you, sir. Thank you for your patience. Okay. Thank you. All right. Okay. Do we have any other waivers that we can address today, or any other people that I have not failed to address as of yet?
Just on the second calendar position for the label, he does not have an attorney. The DOC custody.
I don't think that we have dealt with him as of yet.
He does not have an attorney. He's a DOC custody will provide that.
He is not on the platform today, is that correct?
He will not be.
Okay, all right. We can set him for the 8th of September.
We'll need a waiver. We'll need one of the waiver individuals as well. So
We can do a waiver and arraignment if he's in fact, if he has in fact counsel. We don't know, I don't think he has counsel as of yet.
not yet.
Your Honor?
Yes, who's talking?
Hi, my name is LaShonda Bishop. I'm here with Blaylock at Wilcox State Prison.
Wonderful, okay.
Your Honor, I believe my understanding, he was represented for the purposes of a waiver. I'm not sure if that attorney is here today, but we may be able to do it if that attorney is here. Mr. Whale?
Great level. He's doing.
Okay.
I'm here.
Hold on, let me see if I have you real quick. Mr. Lowell, let me go ahead and, wait 1 second here. I'll put you there. I do see Mr. Brett. Mr. Brett, is there any way you can turn your camera on at Wilcox State Prison, madam? I can.
Yes, sir, give me 1 second.
Okay, wonderful. Thank you, madam.
Sorry.
Yo, but the lawyer did check on me real quick. He checked the judge.
Can you see him now, sir?
The black lawyer, he told me.
No, ma'am, I just see Wilcox State Prison, that's all.
The black lawyer.
Let me see if you're showing up any in the place. I don't believe so. Let's see.
got
Give that camera to say what's up.
I'm sure I'll know his name by the end of these proceedings. But the gentleman standing up with the bald head, he had to check the judge real fast. He's like,
Okay, can you see him now, sir?
Yes, ma'am, I sure can. Thank you very much.
Okay. His last name is
Blaylock. That's my damn name.
Blaylock. His first name is Demond.
nigga, don't talk. Let her do the talking. You need to shut up. Yeah, but I respect that. They've been working together over 20 years. This lawyer and a judge. The lawyer had to check his punk ass one time. Sorry. I demand respect. Definitely respect that.
Mr. Law and Mr. Blaylock, thank you for your patience with us today, okay? I am in, Mr. Law, good afternoon, sir.
Hello, Judge. Thank you.
I'm in possession of a letter that was authored by you on the 31st of 2022. That's the one I'm going to refer to Mr. Blaylock and ask him some additional questions, okay?
Yeah, May 31st, Judge. That's correct.
All right. Mr. Blaylock, where are you, sir? Can I get you to raise your hand for me, please, sir? You solemnly swear from the evidence you shall give in the matter now in hand shall be the truth, the whole truth, and nothing but the truth, so help you God, so from?
Yes, sir.
Okay, thank you very much. Mr. Blaylock, I'm going to ask you some questions. I'm holding a letter that I'm referencing that was authored by your attorney, Raymond D. Law, and that would have been on the 31st of May 2020. Do you recall that having conversation about this letter?
Yes, sir.
Okay. I'm going to ask you a couple of questions about it. I know that you had a privileged conversation about it. I'm not going to ask you any specifics about that particular conversation, only the aspects of the representation involving Mr. Steele, okay?
Yes, sir.
Okay, all right. So, the letter reads that he being Mr. Law, is writing you pursuant to your conversation on Friday afternoon, May the 27th, 2022, concerning Brian Steele's representation of you on direct appeal from your convictions and sentences in Fulton County, as well as Mr. Steele's current representation of Mr. Williams in Fulton County indictment number 22 SC 182273, for which you are named as a co-defendant. Is that the conversation that you had?
Yes, sir.
Okay, hold on one second, folks. I'm having a lot of chatter with someone just see if there's anybody else.
I noticed how you keep the rapper.
Mr. Wiles, I'm going to mute you.
That's a good thing.
Hello.
Keep the rapper names out of
Hey,
it.
this chain.
Keep the name, keep those names.
We have some other people on the platform we're having to mute because, and that's why we're having some issues with, all right, I think I can hear now. All right, sorry for that, folks.
Keep the AKAs out of it.
Okay. So, Mr. Blaylock, did you have a discussion with Mr. Law in regards to the issues the court just brought up? That would be the appeal of your convictions and sentences in Fulton County, as well as Mr. Steele's current representation of Mr. Williams in indictment 22 SC 182273?
Yes, sir.
Okay, and that particular case has also been re-indicted under 22 SC 183572. You understand that, correct?
Yes, sir.
All right. Did Mr. Law advise you, as your independent counsel, that you do not have to waive any issue regarding this potential conflict of interest, and that you can object to Mr. Steele's representation of Mr. Williams if you desire?
Yes, sir.
Yes, sir.
Okay, I'm going to ask you another series of questions that were not in the letter that Mr. Law pending or discussed, but I want to make sure that he did in fact discuss these things with you, okay? To your satisfaction, all right? And
Yes, sir.
I just want to make sure. Do you understand that the state could offer to dismiss the case against one co-defendant, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, sir.
You also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other.
Yes, sir.
You also understand that the lawyer may want to use a defense theory, witness, or evidence or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client.
Yes, sir.
You also understand that during closing argument, the lawyer may want to argue that the evidence against his current client is less than the evidence against the former client. You understand that?
Yes, sir.
If there is a sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, sir.
And the lawyer may have learned something from the former client that helps the current client but hurts the former client. You understand that?
See all these stipulations?
I understand.
Okay. After the explanation that Mr. Law gave you, as well as the questions that the court has asked you, and that would have been on May the 27th of 2022, plus the court's questions that I've asked today on the 18th of August 2022. Do you give this waiver knowingly, freely, intelligently, and voluntarily, and waive any potential conflicts of interest?
Yes, sir.
And that is your desire to do so, is that correct?
Yes, sir.
All right. Mr. Adams, anything else, sir?
Nothing further.
All right, Ms. Rosenwasser?
Yes, Your Honor, I noticed that the court used the language former client. I want to be clear for the record and for Mr. Blaylock. To my understanding, Mr. Steele is actually still currently representing Mr. Blaylock on Mr. Blaylock's appeal. So it's actually two current clients. So I want to make sure that Mr. Blaylock is aware of the conflict arising from the fact that he is currently represented by the state attorney that Mr. Williams is being represented by, and that he wants to waive that conflict.
Let me ask Mr. Adams, okay? Mr. Adams, do you want to address that, sir?
Yes, sir, that is accurate in regards to the appellant matter. Mr. Steele currently represents Mr. Blaylock, and I do not have any objection to the state asking, I guess, clarifying.
All right, go right ahead, madam. He's under oath.
Mr. Blaylock, you understand
Yes,
that
ma'am.
you are currently being represented by Mr. Steele on your appeal.
Yes, ma'am.
Now, all of those potential conflicts that the court explained to you earlier and used the phrase former client, you understand that that applies to you as Mr. Steele's current client and Mr. Williams as Mr. Steele's current client.
Yes, ma'am.
Do you still wish to waive any objection to Mr. Steele representing Mr. Williams since he is already currently representing you?
Yes, ma'am.
And do you understand that the matter he's representing you on is related to the matter that he's representing Mr. Williams on?
Yes, ma'am.
Do you still wish to waive that conflict step?
Yes.
Thank you.
Okay, Mr. Law is, I should say Mr. Adams, who is representing Mr. Blaylock at this point in time? Is he,
I do not believe he's currently
Keep slime on the screen so they're looking at it.
Mr. Law, is that correct, or Mr. Lael? I'm sorry if I mispronounced your name, sir.
It's Lael, Judge. It's Lael. Thank you.
Okay. Sir, were you engaged or hired to represent Mr. Blaylock solely for the purposes of the waiver?
That is correct.
Okay, so you're not representing him on the current matter, is that fair to say?
That is correct.
Okay, all right. Mr. Blaylock, what I'm going to do is I'm going to set your case over for the 8th of September. We'll see if we can still get you an attorney. I can't formally arraign you at this point in time. I'll have to wait until that time, till counsel is appointed, okay? or if you hire an attorney. So if you hire an attorney between now and September the 8th, you can let us know that, but if not, what I'll do is we'll see if we can get somebody to represent you, okay?
Yes, sir.
All right. Any other issues, Mr. Adams or I should say, Mr. Rosenwald, anything?
Nothing on that, Mr.
Okay, Mr. Wall, anything from your perspective, sir?
No, sir, that's all I have today, Judge.
All right, thank you very much for your patience with us today. I know it's been a little bit long time being on Zoom, thank you, Mr. Wall, and if there's anything else, I'm going to release you at this point in time. Mr. Blaylock, we will put you back on for September date, and hopefully we'll have an attorney by that time for you, okay?
Yes, sir.
All right, thank you, sir. Take care.
Boy looking for somebody. See over there, he going through it though.
All right, anything else, any other folks we can conduct whatever issues with?
I know we had waivers with I don't know if Mr. Stillwell on the platform today, but I know he had some conflicts, and I saw his attorney here today.
Let me see.
Mr. Stillwell Jackson I have not seen him on the platform, so I'm not sure if he's here. Mr. Sharp, who represents him, was present.
I know Mr. Sharp was here earlier.
Oh, there he is.
Oh, it is Mr. Sharp. Okay, all right, wonderful.
I don't think Mr. Stillwell is on the platform.
Where is it?
I seen him looking.
I don't think he's on the phone.
He the first one to realize he was.
I don't think he was on the let me see if he is.
Black dude.
Mr. Chamberlain, do we have Mr. Stewart on any one of our,
I'm sorry, I was thinking about who we had conflict for, and that's why I thought of it.
we can put Mr. Stillwell on for the 8th. Mr. Short, will that work for you, sir?
It will, Your Honor. I do have a matter of business, and when it's appropriate, I do need to bring to the court's attention, along with the attorney. But whenever that's appropriate. But as far as
We can handle this in about 10 seconds, so if I may.
Okay.
And I told counsel this because of
Speak up.
that we have communicated better than put into the social.
Was he whispering?
I have informed most of the council that I'm communicating in open court because I can't have everything that's happening here without social media. So Mr. Short asked me a question and I basically responded. I'm only going to respond in open court and nowhere else. I will answer his question without revealing a concern we would have. And I will tell Mr. Short at this time we are clear. There's no conflict there. And I'll just leave it at that, Judge. I think the issue is resolved and I've communicated in open court.
Okay. I know that the state filed a motion on that, a motion. Would you be so kind, Mr. Geary, within the next 4 or 5 days to file an order to that effect?
We will, sir.
Okay, all right.
And multiple copies too. We're running.
Okay, all right. All right, Mr. Short, does that conclude your issue?
I think so.
Okay.
As long as the state's okay with it, I am free with it.
All right, so they're going to do an order, basically withdrawing or otherwise satisfying they have no conflict in terms of your representation of Mr. Stewart.
This is not the one it's called for, Judge. This is a separate question that you want to bring up to the court that I will not answer. So this does not pertain to the motion itself.
Okay, well, I can't deal with that one until we, in fact, get Mr. Stillwell. I don't think he's on the platform today. So we will have to put him on for the 8th. Okay? For rearrangement and for the waiver issue.
To be clear, Your Honor, so we have a conflict alleged against Mr. Sharp, and I didn't we can relieve through there, but we also, Mr. Stillwell has a conflict with Mr. Steele, so as part of Mr. Steele's conflict proceeding, he will also, Mr. Steele.
Okay. That's fine. Mr. Adams, anything on that? Is that correct? Okay, what I'll do is, let me put that on for the 8th. We'll get Mr. Stillwell produced at that point in time, and I can deal with the rearrangement and the 2 waiver issues at that point. Ellie, you got those down? Mr. Chairman? Yeah, we need to put them out for waiver and for arraignment, okay? Okay, alright. Alright, anybody else?
Captain Mr. Williams, I think that's really your only bring to the panel today. Mr. Kendrick, Mr. Stillwell, and the ones that are outstanding that I understand will handle.
Yes, sir. Yes, sir. Okay, are there any other waiver issues that are not dealt with today, folks? That we were able to deal with, because some people were not, either produced or not, we're going to get from the state system. We'll deal with that on the 8th of, hopefully we'll deal with it on the 8th of September. I also have, okay, hold on. He's not been arrested as of yet. Were you talking about Glorious Bradford?
I don't have any information on this.
Mr. Bradford hasn't been arrested yet. Okay, did we ever locate Mr. Myrick? Yeah, I asked, Lieutenant Dooley, was on with us the better part of the day. I believe she had to step away to deal with some other, unrelated business. And, did we find Mr. Myrick?
He's on 7 South.
He was on 7 South 113.
Nope, 7 South 602. Let me call him.
Mr. Thiele, thank you for your patience. Welcome, Your Honor. While we're waiting on that, Mr. Chamberlain, any other holes or inquiry you want to make, sir? Yeah. Mr. Gary?
Judge, on number 17, if you, that's Mr. Nichols.
Hold on, sir.
He doesn't have an attorney to our office, and he's in Rice Street, so we might want to bring him over on the 8th as well to try to do
Mr. Nichols, are you on the platform, sir? I don't believe Mr. Nichols, we have him present on the platform. So we'll have to bring Mr. Nichols. I don't think he has an attorney either, does he?
No, sir.
We'll put him back on for the 23rd, for the,
9/8.
yes, sir, September 8th calendar.
Yes, sir.
Hey, Judge.
Sir, madam, yes.
Do you have a number I can call you really quickly?
(404) 613-8741.
Let's see.
Yes, ma'am.
Judge, I think that's
Okay, Mr. Myers is just give me a second, okay? I'll the jail called me, they just said that they'll bring Mr. Myers back in just a minute, okay? Alright. Is there anything else we can deal with in the Pennsy? Any other issue, any other,
I think we only have Mr. Myrick and Mr. Garland left, and we've got him down as a 2 o'clock.
yes, man, that's about 15 minutes from now. Yes, okay, all right.
Given that, Judge, may we take 5 minutes?
We can, and I will. Mr. Adams, at this point in time, do you have any, hold on, wait, 1 second. Oh, yeah. Hello? Mr. Adams, any updates on the issues to bond, or to have that? Do you still want me to have that today?
Yes, sir. I've had a chance to consult the co-counsel, lead one. We would like to see forward a motion for reconsideration.
Sure, okay, all right. Just give me a minute, I'm just gonna recess in place, Mr. Geary, and head off. If you all wanna take a break, that's fine, just come back in about 5 minutes or so, okay?
Thank you.
All right, thank you. We're in recess. We got some clowns now, calling on my phone. I'm gonna tap phone. Yep.
I thought of that.
Was it?
Man, you can't answer it, don't try to do any kind of communication with someone else. You said what? Okay, well, yeah, for about 5 minutes. Okay.
Yes, sir.
right, yep, right here.
Oh, this ain't the